Okay, so I'm going to talk about the recession. So, for the recession, from what I have understood, it is the cancellation of an obligation that could also lead to extinguishment of the obligation or an obligation. So, compared to annulment, recession is the act of withdrawing when uh, one of the parties would take over or take like withdraw the obligation, and because of the withdrawal, then um, there would be no more obligation to fulfill. So yeah. Lastly, we have here the happening of a fortuitous event. So, an obligation will be extinguished when an unexpected event will happen. So, an example would be, let's say, there's a house and then, ano, kalit siya nasunog, and it's an unexpected event, and no one even wants to have their house burned down, or and then ano then there is this like thing inside the house that is irreplaceable, and that's the only thing that ano that could fully fulfill the obligation to the creditor. So the obligation will be extinguished because the thing was lost and dili na siya mabalik. So, in other words, finish na ang obligation because there's no thing to give na aside the ash, if so that's what I have understood.
So for my part, by novation. So novation in extinguishment of obligation refers to a legal concept where a new party is substituted for one of the original parties in an argument or contract, resulting in the discharge or extinguishment of the obligations of the party being replaced. In other words, a novation occurs when a new party takes over the responsibilities and liabilities of an existing party in a contract, effectively replacing the original party and ending their obligations. Under contract, this can be a complex legal process used in various situations, such as in businesses, mergers, acquisitions, or when one party wishes to transfer their contractual duties another entity. And now we go on to compromise, Article 2028. A compromise in extinguishment of obligation typically refers to a legal arrangement or agreement where parties involved in a dispute or contractual obligation reach a mutual understanding or settlement that results in the discharge or fulfillment of their obligations under modified terms or conditions. So this compromise is often a negotiated resolution that allows the parties to avoid litigation or disputes by finding a middle ground or alternative solution that both parties agree upon on. It effectively ends the obligation or dispute in a way that is acceptable to all parties involved. So the specific terms and implications of such compromises may vary based on the nature by the obligation and the agreement reached by the parties. And knowing that legal advice or consultation may be necessary to navigate such situations appropriately.
Hello, everyone. I'm going to discuss the Article 1193, Paragraph 2 of the Civil Code of the Philippines pertains to the extinguishment of obligation by compensation upon the arrival of resolutory period in the context of Philippine law. Here's what this provision means. Obligation by compensation. Compensation in this context refers to a legal process where two parties owe each other sums of money, and these sums can be used to offset each other. If both parties have obligations to each other and the amounts owed are of the same kind of and quality, this obligation can be extinguished or cancelled out through compensation. This is also known as legal set-off. For the second one is resolutory period. Resolutory period is condition in an agreement of or contract that, when met or triggered, brings the contract to an end, terminates it in the context of Article 1193. The obligations are subject to a resolutory period, meaning that the obligation will cease or be terminated once this period arrives. Article 193, paragraph 2, paragraph, paragraph 2 especially deals with a situation where there is compensation agreement and a resolutory period is set or for the obligation. When this period arises, the obligation will be extinguished through compensation. This means that if both parties have debts to each other and the resolutory period occurs, the debts will be automatically set off and neither party will owe the other anything further. To provide a practical example, for the practical example, let's say party A owes party B 100,000 pesos and party B owes party A 80,000 pesos. They have compensation agreement. If this agreement has a resolutory period set for 1 year, and after 1 year neither party has paid the other, the obligation will be extinguished through compensation. In this case, party A will owe party B a 20,000 pesos because 100,000 minus 80,000 and the rest of the debt will be cancelled out. It's important to consult with a legal expert or refer to the latest legal text to understand the specific application of this provision and how it might apply to your particular case, as the interpretation and application of legal provisions can vary based on various factors, including case law and legal developments. That's it. Thank you.
Condonation or remission is an act of liberality where the creditor gives up his right against the debtor, either in whole or in part, resulting in the extinguishment of the latter's obligation. It is essentially gratuitous and requires the acceptance of the debtor. The reason for the need of the debtor's consent is that one cannot simply impose his own generosity upon another's person. The remission may be expressly or impliedly. When the claim in a pending action is purely personal, the death of either of the parties extinguishes the claims and the action shall be dismissed.
So for the next topic, the extinguishment of obligation by the loss of the things due. So this is a fundamental concept in contract and civil law. When an obligation arises, it typically involves a debtor who owes a specific thing or performance to a creditor. However, this obligation can be extinguished in the subject matter of the obligation, often referred as the thing due, is lost or destroyed. So in such cases, the loss of things due must occur without any fault or negligence on the part of the debtor. This principle is rooted in the idea that it would be unjust to hold someone responsible for fulfilling an obligation when circumstances beyond their control were rendered it impossible. So, for example, if someone borrows a rare book from a friend with the obligation to return it in the same condition and the book is destroyed in a fire, the debtor is relieved of the obligation to return the book. This is because the loss of the book was unforeseeable event and beyond the debtor's control. However, it is important to note that the principle does not apply if the debtor was responsible for the loss or destruction of the thing due, though their own negligence or wrongdoing. In such cases, the obligation remains in force, and the debator may be held liable for the damages. So, all in all, in summary, the extinguishment of an obligation by the loss of thing due is a legal concept that recognizes the principle of fairness and prevents individuals from being held responsible for fulfilling obligations when circumstances beyond their control is made impossible to do so.
So for the confusion or merger of the rights of creditor and debtor, so it is the meeting in one person of the qualities of creditor and debtor with respect to the same obligation. So it takes place when the principal debtor and creditor and the very same obligation must involve. So mutual resistance or withdrawal. So it is where the approval of his loan, the borrower, instead of insisting for its release, ask that the mortgage given by him as security been cancelled and the creditor acceded. Therefore, the action thus taken by both parties was in the nature of mutual resistance, which is mode of extinguishing obligation. So it is an happening of a period and it will extinguish the obligation.
So next, I'm going to discuss annulment. So annulment, in this context, that it refers to a legal procedure that if it declares a marriage or marriage that null and void. So as if had never taken place. So grounds for annulment can include lack of parental consent or psychological incapacity, fraud, and impotence, or being the under influence of drugs or alcohol during the wedding. Annulment is a way to legally end a marriage that was invalid from the beginning. So next is the impossibility of fulfillment, which is in the article of 1266 of the Civil Code of the Philippines, and with the principle of impossibility of fulfillment, it states that when the service has become so difficult as to manifestly beyond the contemplation of the parties, the obligor, which is the person with the obligation, may also be released from the obligation. So uh, in simple context, this legal principle states that it is only fulfilling a contract or obligation becomes impossible due to the unforeseen and controllable circumstance that the party is responsible for fulfilling the obligation might be released from the obligation itself.
So now we'll proceed to the extinguishment of an obligation by prescription. So this is a legal concept that deals with the lapses of time as means to end legal claims or obligation. This concept is often governed by specific laws and regulation outside the civil code of many legal system. So prescription essentially means that if a creditor does not enforce their rights or claim the fulfillment of an obligation within a specific period, those rights can be forfeited. The idea behind prescription is to promote legal certainty and prevent disputes from lingering indefinitely. So these time limits can vary depending on the nature of the obligation and the jurisdiction. For example, in many legal systems, contractual obligation might have a different prescription period than personal injury claims or property disputes. Once this prescribed time has passed without action from the creditor, the obligation considered extinguished and the debtor is no longer legally obligated to fulfill it. So, prescription rules aim to strike a balance between the rights of creditor to enforce their claims and needs for legal closure. And predictability, they also ensure that individuals and entities are not perpetually burdened by unresolved obligation, which could disrupt their personal and business affairs. So, basically, in summary, the extinguish of an obligation by prescription involves the lapses of specified period of time after which the creditor claimed to enforce an obligation is no longer valid. The specific rules governing prescription are typically found in separate legal provisions or a crucial for maintaining the functioning and fairness of a legal system.
So based on the book, payment or performance is, in ordinary parlance, payment refers only to the delivery of money. As a legal mode of extinguishing an obligation, it has a much wider meaning. Payment may consist of not only in the delivery of money but also the giving of a thing other than money, the doing of an act or not doing of an act. So, in simple words, payment is the or performance is the fulfillment of an obligation to pay money. A person under such an obligation is called a debtor, and a person to whom the obligation is owed is called a creditor. The obligation may arise in various ways, but it is most commonly the result of commercial transaction or contract between parties. When a debtor pays damages or penalty in lieu of the fulfillment of an obligation, it is on Article 1226. There is also payment in the sense used in Article 1232. In law, payment and performance are synonymous. So, fulfillment for resolutory conditions, it is on Article 1190 stated that when the conditions have for their purpose the extinguishment of an obligation to give the parties upon the fulfillment of said conditions shall return to each other what they have received. So, in simple words, each party is required to give back to the other any payments they have made as a result of an obligation upon the satisfaction of a resolutory condition, just as if the obligation had never existed. So, in case of loss, deterioration or improvement of the thing, the provisions which, with respect to the debtor, are laid down in the preceding article shall be applied to the party who is bound to return. As for obligation to do and not to do, the provisions of the second paragraph of Article 1187 shall be observed as regard to the effect of the extinguishment of the obligation. It is on 1123 article.